Good morning and welcome. It's very nice to see so many of you here. You guys are the stalwarts who, after dinner and dancing, can show up at 9 in the morning. So thank you for being here. And thank you for watching on the live stream or the recording later. I am Dean Reuter, Senior Vice President, General Counsel of the Federalist Society. My pleasure to welcome you all here this morning to the continuation of our 40th anniversary in the National Lawyers Convention. I hope you had a great night last night. I did. I hope you were all able to attend. I want to acknowledge what I would describe almost as the heroic efforts of our staff to pull that dinner off. Some of you might be aware, but you might not be aware, that behind the scenes for the last 5 or 6 days, we were having a technology collapse where data, your seat assignments, your table assignments would be entered into a system and then transported to a seating app, and it would then evaporate and we'd start over again. And, we've had some staff in the office for 48 hours continuously without going home. So I think we were only able to push this over the finish line because of their efforts. And literally in the hours before the dinner began, we were concerned that we might have 400 empty seats in the back of the room, or 300 people with duplicate seat assignments. And we had no way of knowing which way it would go, but it worked out. So thank you to the staff for doing that. Now, as to the format last night, I thought it was a winning format. There was a lot of angst about surprise speakers, who's going to be the speaker. And I thought I would explain that briefly, that I had made some personal promises to speakers that their identities wouldn't be disclosed, and I stuck to that. It actually made the staff of the Federalist Society crazy, because within the building I knew and Gene knew and no one else knew. And it was an interesting, last 4 or 5 weeks watching them try to jockey to get information as to who the speakers were going to be. But I really, really didn't want to be personally identified or have the Federalist Society identified with what could be characterized as a Supreme Court leak. So that's why we kept that information close hold. Anyhow, a couple housekeeping announcements. Use the QR code. It was going to be on the screen. It's certainly on your cards. If you need CLE credit, you need to sign in the morning. You need to sign out in the evening. Otherwise, you're going to have enormous problems with your state bar, and we will not be able to help you. And I want to take a moment again to remind folks of the Rare Documents exhibit. If you haven't been up to the South Carolina room on the 2nd floor, it is really, really impressive. I listed some of the documents that are up there yesterday. I won't go through that list, but what I gave you yesterday was really just a partial list. It's really impressive. And there is a drawing. I explained yesterday the Federal Society has never had a drawing before that I'm aware of, but we've also never had a leaf of a first edition Federalist paper that you can win. So do go up there in any event. And these are documents you can actually leaf through. I was leafing through Blackstone's original commentaries. It's extraordinary. Now, today's first panel continues our examination of the current state of the legal profession, now focusing this morning on the mission of law schools, which, of course, reminds me of a very brief story. Now, I told this story maybe 20 years ago, but I'll retell it because somebody asked me again to retell it. And at the time of this story, I was a young man, pretty much looked like I do now. A recent law school graduate, and I had just passed the bar exam. This is how the mission of law schools comes into this story. And I decided to celebrate and treat myself by buying a new suit. Now, I was working as a government employee at the time, and I went to one of those warehouse clothing stores, aptly named Men's Wearhouse. Now, the store name, I should say, is now, in this era, probably a microaggression, Men's Wearhouse. So I'm not endorsing it, I'm just really telling a story. So I walked into this store and I was greeted by a man even younger than myself, younger than the airport guy I described yesterday, and he was very eager to make the sale. And I assume he wanted to, get that commission on what at the time might have been a whopping sale of $129 for a top-of-the-line, very cheap suit. I told him I needed to buy a suit, and he said, "Well, what kind of suit are you looking for?" And I said, "A suit I can wear to court." And I saw his face just collapse, and he said, "Oh man, what did you do wrong?" And I had the presence of mind to say, "Well, I passed the bar exam." And that remark went over his head. He didn't understand that. But I got my suit and he got his commission and it all ended well. But the point of the story is my experience with law school and with the legal system is very positive. It's the way I make money, and it's probably the same for you. But this young man's experience with the legal system was the court system, was as a litigant, and that's true of many, many people in the public. They're in high-pressure moments when they've got a lot at stake. Maybe they're negotiating, maybe they have child custody at stake, whatever it is, and they have to rely on the expertise, the costly expertise of a professional. So we're asking this morning, how are law schools doing when it comes to preparing those lawyers, to preparing those professionals? And for that, we're turning to a great panel of experts led by DC Circuit Court Judge Naomi Rao. Now, she is a Federalist Society regular. She asked me to be brief in introducing her, and I will be. She's a clerk of J. Harvey Wilkinson on the Fourth Circuit and Clarence Thomas on the U.S. Supreme Court. She's a veteran of private practice, the executive branch, academia, and more. And she's been on the DC Circuit Court. The DC Circuit Court, of course, touted by everyone except the judges here that are on the numbered circuits as the second most important court in the country. She's been on that court since 2019, and we're very pleased to welcome her back. Judge Rao.
Thanks so much, Dean. It's great to be here. And one of the things I've learned is being at the Federal Society for a number of years, now that it's 40 years, people can start retelling the same stories they told at conventions long ago. So that's great. And as to being on the DC Circuit, when I was confirmed, a friend said to me, they was like, well, you know, Naomi, being on the DC Circuit is kind of like the Yale Law School of circuits. You know, half the work, double the prestige, you know. So, I went to the University of Chicago, so I can say that. So anyway, it's great to be here to talk about this important topic, the mission of law schools. I mean, because really this question, you know, what the mission of law school should be is really a question also about what is the mission of the legal profession. And, you know, there's some very basic questions, you know, what should young lawyers be learning? What types of habits of mind should they develop? Those are kind of basic questions, but I think this, you know, the mission of law schools also raises a number of very profound questions about what is the role of the rule of law in society. Lawyers are the people who are at least on the front lines of maintaining the rule of law and its place in society. So how do we educate the people who do that? How do lawyers help maintain the habits of mind that preserve the rule of law in our broader society? I think these are all really important questions, and we have a great panel today to discuss that. Their full bios can be found in the material, so I'm just going to give a very brief introduction in the order in which they will be speaking. And we're going to start with Professor Mahoney, who's professor at the University of Virginia Law School. We will next hear from Dean Dana Matthews, who's also a professor at George Washington Law School. And then we will hear from Dean Mark Alexander, who is professor and dean at Villanova Law School. And then we will hear from Professor Josh Kleinfeld of Northwestern Law School. Thank you. Professor Mahoney?
So I believe that my fellow panelists will drill down on some of the specific things that law schools are doing well and not so well at present. So I'd like to start with a few basic points about law and legal education that I hope might illuminate where we are and how we got here. The United States is one of several countries that acquired its legal system from England, so it's part of a legal family that we refer to as the common law as a shorthand. And like all legal systems, it developed in a particular economic and social context. And particularly in the Anglophone countries, the common law came packaged with a preference for market allocations over administrative allocations of resources, and a priority for individual rights over collective rights. And these are not just chance associations. The institutions of the market economy and individual rights co-evolved with the common law. I teach contracts, among other things, and comparative scholars have pointed out that continental European contract law tends to have more mandatory provisions, more terms that the parties are not able to alter. And that's just a very small window into the somewhat greater emphasis on the individual in the common law versus the collective in the civil law. And of course, a core concept of the rule of law, as we understand it in the United States, that everyone is equal in the eyes of the law, presupposes that individuals have rights as such. Now, intellectuals, and therefore universities, have historically been less sympathetic than the rest of society toward markets and individualism. Now, until relatively recently, though, that fact had limited relevance to legal education. For most of their history, law schools were staffed primarily by lawyers with deep connections to legal practice who focused on teaching the craft of legal argument and legal representation. They were part of universities in much the way that football teams are today. Parties to a marriage of convenience, but engaged in rather different tasks. But over the last half century or so, law schools have increasingly taken their intellectual cues from academic disciplines such as philosophy, history, sociology, literary theory, psychology, economics. And this has greatly increased our understanding of law and legal systems. But like all good things, it comes at a price. Law professors have lost most of their connection to legal practice, and they have become immersed in the values and preoccupations of faculty in the humanities and social sciences. Now, I need not summarize for you the data on political affiliation among university professors, other than to remind you that it is extremely one-sided. But more important than that, in my view, is the migration into the legal academy of the notion that markets are inherently unfair and that, if anything, the preference should be for administrative allocation of resources. Alongside that sits the idea that rights should attach to groups as such as a way of correcting historical injustices, whether or not the particular individual group member was actually a perpetrator or victim of those injustices. And that in turn suggests that the right to speak, to assemble, to petition are dependent on the identity of the group on behalf of which one purports to speak, assemble, or petition. Well, these ideas have been prominent in the academy for a long, long time. So I suspect that the reason that we are here today is because they are rapidly migrating into the rest of the society. And indeed, I think that the problems or the issues that this panel was formed to discuss are evident not just in law schools, but throughout the legal profession. Many bad ideas certainly continue to originate in the academy, but they find an appreciative audience outside it. So I think that the deeper issue than a simple tension between teaching law students how to serve the interests of their client versus the interests of some social goal is that many law professors, practicing lawyers, judges, and legislators no longer view Anglo-American law as a set of substantive principles of social order that are premised on a market economy and individual rights, but instead as a set of procedural and tactical tools that can and should be used to turn the society into something different, perhaps something premised on a planned economy and group rights. So I believe that part of the mission of law schools is to teach our students that law is not a collection of unconnected rules, not just a tactical toolkit, but instead a system that helps to sustain and nurture the society of which it is a part. And the form of that system is necessarily connected to the form of the society. Our legal system arose to support a society that was based on markets and individual liberty. So I would advise anyone in the audience who teaches law, whether as a full-time faculty member or a legal practitioner who teaches an occasional adjunct course or guest lecture, to emphasize the connection between Anglo-American law, the market economy, and individual liberty. No less an authority than Adam Smith, the founder of modern economics, drew a connection between property rights and the division of labor. He noted that secure property rights led to increased agricultural productivity, which led to a decrease in the number of people employed full-time in agriculture and an increase in those employed in manufacturing and commerce. Because the division of labor is central to a market economy, so too are property rights. The connection between contract law and commerce is even more obvious. Indeed, a system for enforcing contracts is so essential to non-simultaneous trade between strangers that medieval merchants went to the expense of creating their own system, the law merchant, at a time when sovereigns lacked the inclination and resources to take on the tasks themselves. So what about those of us who also teach a non-core common law subject? I'm a securities regulation professor primarily. Here, I think it is important to focus students' attention on the fact that regulation of necessity impinges on the exercise of property and contract rights. And historically, the justification for those restrictions was the existence of externalities or market failures. So when we talk about regulatory rules, it's worth asking, what market failures did Congress or the agency identify? What evidence did they provide that this rule is going to address that market failure in an effective way? I think we can't spend too much time emphasizing the connection between our legal system, markets, and liberties. In sum, I think much of what gets attention today, guest speakers being canceled and so on, are symptoms of a broader problem. And that problem is the failure to defend the economic and political system with which our legal system came packaged.
Thank you so much. Dean Matthew?
Well, first let me say that I'm sitting next to a very dear friend. We were colleagues at the University of Virginia, and together with Professor Mahoney's wife, I consider you a person I would like to have dinner with again soon.
We'll do that.
And the reason I have to preface my remarks that way is because, as you might imagine, because I would have been considered an object of the property that Professor Mahoney describes in the Anglo system and a subject of contractual rights at the time of the origins of our legal system, I have a slightly different view. I am not going, however, to delve into the depths of what legal education does practically. I will disappoint in my opening remarks, but happy to do that in the question and answer, but rather just shape, if I may, a few larger principles about what informs my view of the mission of legal education. I'll take as a source of my remarks the first woman president of my alma mater, Harvard University, Drew Gilpin Faust. In 2010, she gave some remarks at the Royal Academy at Trinity College Dublin, a place that I spent a wonderful summer, And I want to start with some observations that she shared at that occasion. So universities, of course, generally hold a very important, indeed a paramount place in the global system of economic preservation. And knowledge is so important today, ideas and innovations, that the economies and the property rights that are important to those economies cannot be sustained without universities, and in particular universities that include great law schools. A university education is an absolute necessity for individual success, of course. College education, and indeed a legal education, multiplies lifetime earnings terrifically and enhances, therefore, employment, wealth, housing, education opportunities for generations. On a societal level, a university education, and indeed a legal education, contributes as a driver of economic success. A society globally does better when innovation, ideas, and the exchange thereof are proliferated and shared across different economies and different societies. Law particularly serves much more as an economic engine than we give it credit for, and therefore I have no quarrel, no objection whatsoever to including in the education of our law students and the system of our canon, if you will, the importance of property rights, contract rights in the Anglo tradition. However, I believe that law education in particular does much more than to preserve the economic opportunities of either an individual or collectively of a society. Indeed, and now here I do quote President Faust, "As other institutions falter in dispiriting succession, universities, and I will insert law schools, nurture the hopes of the world." Indeed, I think that's the mission of legal education. I'll repeat it: to nurture the hopes of the world. How do we do so? I'm continuing to quote President Faust. "We do so in solving challenges that cross borders, that unlock and harness new knowledge, in building cultural and political understanding, and importantly, in modeling environments that promote dialogue and debate." So here I'll pause for a second and speak specifically about how we do that at GW Law, my institution. And for this, I want to refer to our history, just to be clear that the Anglo-historic tradition is very important to my understanding of the mission of law schools. So the George Washington University Law School exists to have an impact because of its history. It opened its doors in 1865. Indeed, in August of 1865. This is very important because in May of 1865, I have a photograph, one of my favorites since I became dean, that shows a beautiful picture of the Union Army marching down Pennsylvania Avenue. It was a review of the victors. The Capitol is in the background, and in the foreground are proud generals on horses and then infantrymen on foot. So that picture was taken in May. 3 months later, June, July, August, someone decided that it was important to open the nation's first and oldest law school in the Capitol, and that was the predecessor to my law school, GW Law School. So I asked myself, why? Why at a time when the country was at its most divided, at a time when bloodshed had been so liberally spilled, and no one knew the future of our country or whether we could reconstruct this ideal called America? Why did we need a law school? Well, I answer that and posit to you that we needed a law school because lawyers are essential to the hopes of a society, to the building of bridges, to the resolving of conflicts, to the bringing of unity across divides, whether they are in families, in nonprofit organizations, in corporations, in nation states, indeed in the world. I submit to you that the mission of a law school is to nurture the hopes of the world by modeling that knowledge can be used to solve the most pressing challenges of our time. Thank you.
Thank you so much. Dean Alexander?
Sure. Thank you very much. And I'm really quite happy to be here today for this conversation. I'll offer a few remarks, and I do look forward to any conversation we have afterwards. And I'm also already struck by both of my predecessors here talking about nurturing society, says Professor Mahoney, nurturing the hopes of the world, says Dean Matthew. And I guess I didn't have the word nurture in my remarks, but that is really what I think we're talking about. What are we doing here in law schools? And that was sort of the call for us to address the mission of law schools and our role as gatekeepers of the profession. And I am proud to be the dean because of how we do help move our society forward, how we, I guess, help to nurture the course of society and the future of law. And we exist, in my perspective, we exist in what we do. We exist within a system of laws. And it's a system, I think about today being Veterans Day, a system which all of our veterans have fought to protect. All of us as lawyers are sworn to protect our system of laws. And as a dean, I am dedicated to preserving our system of laws and protecting our democracy and training the future lawyers as they will represent their clients and protect the system of laws. And that requires us to think about the rule of law and the norms that uphold our society and the common good. These norms and rules that have held us together as a nation for nearly 250 years. We're getting towards that, wow, 236 years. And our democracy has endured throughout the years because of our commitment to the norms and to the rule of law, things that have been a rudder that keep us moving forward as a democracy. And throughout every era, lawyers have been central, and lawyers remain central to protecting our democracy and carrying out the norms of our society, touching nearly every aspect of American life. And so the future of law really is in our hands here in this room, but also those who follow. And together, professionally, we must adhere to and enforce the norms of our democracy. And so as a dean, I ensure that the education we provide fully prepares our graduates to serve as principled lawyers and leaders. They will represent individual clients, individual cases, individual matters. They also understand the oath they're going to take as lawyers and the importance of their role in preserving and protecting our democracy and upholding the rule of law and upholding norms. And everyone here understands the rule of law. In fact, the judge referenced the rule of law and how important it is. And that fundamentally keeps our nation together. But I do want to make sure that our lawyers understand, our future lawyers, our students understand their role in protecting and preserving our way of life. And I do want to make sure in the context we live in today that we provide the tools for our students and our future lawyers to be civil as they safeguard democracy. I want them to be diligent as they safeguard democracy. And that is all part of our collective work to participate in forming a more perfect union, committed to the rule of law. Because our democracy does not exist without the rule of law. That is our lifeblood, and it requires a commitment to norms. So we must uphold the rule of law, and I must train my students, again, to be excellent lawyers, but it's more than that. It's to do more, to make sure we uphold the system which we all are speaking about today. As professors and deans, we are training students to engage in the practice of law. The judge is essential in enforcing the norms and declaring what they are. And we must stay true to our profession and stay true to the rule of law and the ideals of democracy. And so a law school education will prepare our students to understand and to uphold the rule of law and its protections for the individual and institutional clients. What we do is we have a curriculum that's rooted in academic excellence, so our students learn to think and deliberate critically and inclusively. We prepare our students to serve as advocates in an ever-evolving free and just society. We create learning conditions that allow for the free expression of divergent views and respectful discussion and debate. We create a vigorous learning environment that prepares lawyers to tackle legal challenges. We must create a place to innovate and advance the law while upholding the truths that we hold as self-evident and the rule of law that protects us and our democracy. The lawyers we are training today will indeed take on significant challenges in the days ahead. They must be prepared to deliberate legal philosophy and legal theory to address complexities we are just now facing and the complexities that are still to manifest, so that as we train them, these students must be ready for the new frontiers that will require as much an understanding of how to think about the law as knowing the law itself. So we graduate lawyers who will bring light and truth to every situation they encounter, as lawyers, citizens, judges, elected officials, appointed officials, under the rule of law, towards safeguarding and protecting the common good and protecting our democracy. We must graduate lawyers who are capable of respectfully and earnestly engaging in difficult discourse. And so in doing that, we prepare lawyers both to represent clients, but also in the big picture to serve as relentless stewards of our democracy. Not just technicians, but like all of us here in this room, principled leaders. Excuse me. And in that context, to develop principled leaders, we need broad-minded preparation. We need preparation for our students that will be inspired and cultivated and advanced by our law school faculty. We need principled leaders who will engage in difficult discourse while purposely honoring our democracy, the rule of law, and the norms of our civil society. Our learning environment, the law schools, must serve as a crucible with conditions that never silence any voice or idea that is presented respectfully and honorably. But that is a challenge today, how we engage in that. At Villanova Law, we are focused on both preparing our lawyers for practice excellence and instilling a foundation that commands honor and leadership, irrespective of politics or perspective. We train every lawyer we graduate to earn trust through ethical and noble comportment, as well as through technical expertise. As Dean of Villanova Law, we are a Catholic Augustinian school. I reflect on St. Augustine's teaching. St. Augustine instructs us, nothing is to be preferred to the search for truth. That informs our approach to the entirety of the educational experience. We promise our students that we'll train them, and we promise them that they need to be ready, and we promise them that they will be ready to take care of our system and to be engaged in the never-ending pursuit of a more perfect union. So in that context, we need them to uphold our democracy, uphold our norms, and show the courage and character to pursue justice in good faith, grounded in facts and evidence and the law. We have been facing challenges in the last years in that regard, in many ways. We've been facing instability, worry, turmoil. And as we look at where we have been in these last years, I know that our mission is stronger than ever. And I, as a dean, training the future lawyers, I ask you, all of you, I call on you, and I join with you. I join with all of you, and you're joined with my students, and Dean Matthews' students, and all law students, to protect democracy. That requires daily work and a commitment to shared values. It requires participation in American self-governance. It requires an adherence to customs and norms. We know that the founders had a vision that is aspirational, a clarion call, framed in a few words in the Constitution. We have developed, maintained, and enforced customs and norms that serve democracy through our commitment to democratic dialogue, to free expression that will further democracy. So as a nation, we must pursue universal wisdom, universal truth, through open, intelligent, responsible, and respectful interaction of differing points of view. The model right there to my right, two longtime friends who disagree, talking about breaking bread. That is our challenge. And in my law school, and I believe in all law schools, we have to welcome people of all perspectives to have those kinds of conversations. So when I welcome speakers to my community, I invoke our university motto, Veritas, Unitas, Caritas. We translate truth, unity, and love. We seek direction from those words, and they point us forward in these times. So we are in the business of ideas, a constant pursuit of truth. We welcome people to come into our community, whether we agree or disagree. And because we know that as we pursue truth, we grow the most by confronting the ideas that sometimes challenge us and responding. We all educate ourselves as we listen to those who come to listen to us. We seek ideas and information to develop ourselves and our understanding of facts and opinions and ideas. We reject polarization. We reject the kind of polarization that corrodes our democracy. We must be the home of the brave pursuit of truth. And what we know at Villanova, and what I believe all of us in this room know, is that we rise and fall as a community, unified in our commitment to the law. We openly welcome and confront varying perspectives, but we must do so with respect and with a commitment to each other and to our love, care, and concern for one another. So when anybody comes to speak at Villanova Law, just as I believe when anyone comes to speak at the Federalist Society, we ask for reciprocal respect. We know we will grow if we can come with love, respect, and open, honest debate about ideas. I do not require any political litmus test, no religious litmus test, no market-based litmus test, no democracy-based litmus test. There are no litmus tests. Each person can and must engage in our discourse. And in that context, I urge all of you, all of us, to provoke thoughtful discourse in order to keep our republic. I join with you so that we all, as principal lawyers and leaders, can show the way to the lawyers of the future, to my students, to Dean Matthews' students, to all the students of the 200 law schools around the country. Help them see the way to ensure our democracy endures and the norms flourish, no matter how difficult it may be. I'm not here to appeal to you as a left or right or center or Republican or Democrat or anything. I'm here just to appeal to all of us and our commitment to our Constitution, to our system of laws, the rule of law that hold us together. I know that my law students are listening and watching, and we all join with you. If we live up to seeking truth, unity, and love, our best days as a nation are ahead of us, and the future of the law and the future of our great country will be bright. So nothing will be more important as we seek to preserve our country and grow as 50 states united with a citizenry committed to country. Thank you.
Thank you very much. Professor Kleinfeld?
Hi, everyone. Thank you. I want to talk about free speech in law schools today. There's a lot of discussion in public milieu, and I assume many of you are familiar with it, about the problem of cancellations in law schools. Cancellations are a problem, to be sure, but they are also just the tip of a very, very, very big iceberg. And my sense is that among practicing lawyers, there's a natural tendency to sort of anchor your impression of law schools to your own experience. That's perfectly normal. But with an iceberg, there's what the surface dwellers can see, and there's what the fish can see. And as an academic, I'm one of the fish. And I thought I'd tell you about what the iceberg looks like from here. So I'm going to advance a thesis today. My thesis is that something momentous is happening. Something in many law schools has happened in our time. It's not one grand policy change. It's the sedimentary accumulation of a lot of small changes. There's a great line in Hegel's Logic where he says, if you pluck enough hairs off a man's head, eventually he's bald. It's about how the differences of degree can eventually add up to differences of kind. And I think that is what has happened at our law schools and our broader universities. It's a paradigm shift. Paradigm one, yesteryear, law schools were broadly left-leaning, to be sure, but they were also basically committed to open inquiry based on argument and evidence. And there was sometimes tension between those two facets of law schools. They're by and large liberal or progressive faculty and students and their broader mission to open inquiry. But it was a managed tension, and the official ideology of the law school was just a general sort of commitment to law as such, very much the kind of commitments that we just heard from Dean Alexander and that I honor. In paradigm two, the emerging paradigm of the present, law schools are committed to an ideology, which is really an ideology of the institution as such. It's a substantive ideology. Acceptance of that ideology is becoming the price of admission to the governing class. It's enforced both by social sanctions and, this might surprise you, an increasingly formal system of official sanctions. And the institutional project, the mission of law schools, to use the name of this panel, starts to shift. It becomes one of training and sifting the American elite for ideological acceptability. So this is a big claim. I only have 10 minutes. I thought what I'd do is tell two anecdotes that I think are representative and illuminating, and just unpack the anecdotes for some of the general patterns that they evince. Okay, anecdote one. One of my students arrived in college from a family of modest means. He was the first in his family to go to college. It was the beginning of his freshman year. He was 18, and he was naive. And he was in a class that was discussing why women and men frequently go into different career fields. He raised his hand and suggested that the reason might be some sort of natural or genetic difference in men's and women's preferences. The other students took offense. I think no one will be surprised by that. But it didn't end with that. The other students organized over social media to track his movements around campus, so that anywhere he went, students would ping each other with his location. And they'd go and they'd mock him or denounce him wherever he went. And this went on for about a semester. I'd like to unpack that anecdote. First of all, if it shocks you, I respectfully submit that you have underestimated how extreme the atmosphere in universities has become. That anecdote is a little unusual, but not radically so. It should not shock someone who is familiar with the present atmosphere. What is happening in law schools and universities is extreme, and I think it's a good warning to beware of anchoring, to beware of the very natural human tendency to think that, you know, most of us or all of us went to law school, most of us or all of us went to college, and it's natural to understand the present by relating it to our own past. But that can mislead insofar as there's been radical change. So that's my first takeaway. Here's the second. The anecdote nicely demonstrates the culture of aggression and even cruelty that now prevails among many, though by no means all, students. There are a group of students, reliably a group of students on most campuses, who are prepared to harm in the name of ideology. I think this readiness to harm is of great political interest. There's a burgeoning literature on the woke movement, and it's typically focused on the substance of the ideology. Much of it's fascinating, but I wonder sometimes if the substance of the ideology doesn't much matter. What really matters is the willingness to harm in the name of ideology. If you think about, for example, Marxism in early 20th century Russia, or jihadist Islam in early 21st century Saudi Arabia, or inquisitorial Catholicism in 15th century Spain, what binds them all together is the willingness to harm concrete individuals in the name of ideology. The ideologies come and go, but the creation of a group of people ready to do harm in their name is important in political history. And on that note, I want to present to you a question just for your private reflections. How often have you set out to harm another person? Not as a side effect of some duty. You know, maybe you have to select someone for a job and the person not selected is inevitably disappointed. But an active and voluntary effort to harm. Try to get someone fired who is not at your workplace, or make someone friendless, or shatter their reputation. I'm going to venture a guess. For many of you, as you reflect on your own history, the answer is never. Or, well, there was that one time in middle school, maybe twice. It's hard to get normal people deliberately to inflict harm. And it is remarkable that there is reliably a group of people on most campuses who are prepared to do it. One more remark about this, it doesn't take much to radically change a culture at a university, or indeed in any institution. Just think about the typical 18-year-old who doesn't want to have a horrible, scarring, traumatic experience of college. They'll see my former student, see that, I don't know what it was, I think a Twitter group or a Facebook group, following him around on campus, tracking his movements, and they will get the message really quickly about what the boundaries of acceptability will be. And they'll, by and large, abide by it because we don't expect people to martyr themselves. Okay, anecdote 2. Anecdote 1 was mainly about student culture. Anecdote 2 is mainly about institutional factors. A few years ago, a law professor I'm friends with retired. This is relevant to the story. My law professor friend is a pretty left-wing guy. He would proudly self-describe as a socialist and is politically defined by his commitment to socialism and to civil rights lawyering. He was also a little young for retirement, and I asked him why. He said a group of his students got upset with him in class, and they brought a complaint against him in the university's Office of Equity, stating that he had said various racist things in class. He was investigated. It happened that he had a recording of the relevant class sessions, and he could prove that he never said the things that he was accused of saying, never said anything like that. They were just falsehoods, they were just lies. The investigators just pivoted, he told me. They said, "What did you do to make them feel that you had said such things?" My friend turned to the law school administration for support, and of course they wanted nothing to do with it. They washed their hands of him. Now he was tenured, so he was not fired. But he was encouraged to retire, and he had had enough, and he took the package and walked away. So now I'd like to unpack this anecdote. I think the first takeaway is the power of the offices of equity at universities all over the country. Depending on when you went to law school, offices of equity might not have existed or might not have been particularly visible. They are now among the most active and powerful offices of any university. These are not administrative assistants. These are powerful university officials earning hundreds of thousands of dollars, typically earning more than professors, or in many cases earning more than professors, and armed with investigative and enforcement powers. And there are a lot of such officials. They have a huge caseload. So functionally, you think about this in terms of legal categories, they are an internal administrative agency that proceeds by doing agency-style litigation. The result, at least at some schools, is that equity complaints are a perfectly normal part of university life. Students file them against each other quite regularly and file them against their professors. Professors are filing them too. Professors file Office of Equity complaints against one another and against students and against administrators. And staff file, everybody's filing complaints against one another. It's part of the culture. Complaints trigger mandatory investigations. complainants are insulated from retaliation. So it's often strategic to file, of course. If you feel like someone else might file, you file first, that kind of thing. And there's typically no dismissal procedure for frivolous complaints and no sanctions for frivolous complaints. So there's no 12b6 procedure or Rule 11 procedure. I know of one major university in which there were so many complaints to the Office of Equity that many employees simply couldn't handle the volume. And they started to outsource it to a local labor law firm. But the law firm couldn't handle the volume. And now there are multiple law firms basically working full-time for the university, processing mandatory student complaints. And these labor lawyers are just interviewing professors. Did you say this? Did you say that? What was in your heart? That sort of thing. I want to point out two things about this phenomenon. First, it amounts to a formal structure of sanctions in favor of the diversity of ideology. The Office of Equity doesn't police all wrongdoing. It only polices allegations of wrongdoing against protected classes on the basis of some sort of discrimination or hostility to a protected class. It usually involves sorts of speech crimes. The old paradigm was that there's peer pressure to conform. This is not peer pressure. These are formal institutional mechanisms, formal institutional sanctions. Well, that's my timer. I better wrap this up. The other thing to point out is that this has made teaching a lot less fun than it used to be. Professors, every professor I know is afraid of their students. Defensive teaching, like defensive medicine in the era of excessive tort suits, defensive teaching has settled in. And it's affecting things in myriad ways that are not particularly visible. This is that part of the iceberg that's under the surface. No one sees what decisions we make in our classroom to deal with the present environment. But I know professors who are asking out of core courses that they've taught for years. Professors who are reverting to pure lecturing because they can't risk discussion, a very scripted discussion. Professors who insist on recording all of their classes just for defensive purposes. Some law schools now insist, as a matter of policy, on recording all classes. Professors who do various virtue signaling in class to forestall accusation. Typically, you can do it with hypos. You just make sure your hypo involves a protected class victim and how to protect that class. And this shows in the numbers. A decade ago, the number of aspiring law professors was about 1,000 to 2,000 a year. And that number has fallen to about 300 to 400 a year. So it seems like people have gotten the message, though it's always hard to pick out causality. I'll just close with this. I just want to close by saying something about the role of the administration in my anecdote. When some person gets controversial, an internal or external person, a professor or a guest speaker, there's a relatively consistent administrative script that gets followed. The cardinal rule of the majority of administrators is never to be outflanked to the left. And so often there'll be a public statement in support of free speech, but also a public statement denouncing in the name of the law school the content of the speech in question. So the law school doesn't represent itself as substantively neutral in many cases. It represents itself as having an ideology. Meanwhile, if the speaker is untenured, he or she will be fired. And if the speaker is tenured like my friend, he or she will be sidelined or gently retired. All right, thank you.
Thank you so much. So we'll have some moderated discussion and then we will open it up for questions. But one of the things I thought was interesting listening to all of these interesting remarks was the wide range of agreement about what law schools should be doing, right? Preserving and protecting democracy, nurturing civil discourse, preserving the norms and the foundations of our society. So there seems to be a lot of agreement about that. But then there seems to also be some concern that maybe what we agree about law schools should be doing is maybe not happening on the ground. as Josh just mentioned. So I'm wondering if the panel would like to speak to perhaps the disconnect, if they think there is such a disconnect, and what can be done about that.
I would just say, I guess maybe I would say, Professor Kleinfeld, come to my faculty. You can leave your school, come to mine. I mean that in a genuine way. Like if that is an environment, like, because it's troubling to me to hear you say, and it's just really, it's upsetting, talking about people doing harm, and that's so antithetical to who we are at our school. And you're so right. Like, challenge us to think besides the third grade playground, when were we doing that? And I worry that we are sitting here, and that a colleague of mine at another school is expressing this as the life he has. And I'm not picking on your school, but there's the feeling that there are folks out there who seek to do harm. And what I do every day is I tell people that we must treat each other with love and respect as brothers and sisters. And I think that is extraordinarily important for us to think about how we treat each other. And it is perhaps my own relentless pursuit of what I think our school should be like, and frankly what all schools should be like. That if there are folks who are seeking to do harm, then I say to them, I reject that. And it's not an ideology of left or right. I don't care where you're coming from. If you are seeking to do harm, you don't have a place in my school. And so, I am trying to create that environment that rejects the approaches you talk about, that embraces people having honest discussions and disagreements, and setting the conditions for us to all thrive in pursuit of truth with open debate. And we're going to disagree on things, and that's fine. We're going to do what is happening over on that side of the room with Paul and Dana. We're gonna go out and have dinner together and disagree on things. But I think it's really hard, I will admit. But I think I know there's so many of us who are deeply committed to that kind of approach of respect, love with each other. And I'm not going to stop working that way.
So I should probably say at this point that in addition to teaching at Northwestern, I've taught at Stanford and Harvard and guest taught at a number of other schools. And my remarks were not about Northwestern. My remarks were just about the law school environment broadly. And my anecdotes were pulled from multiple schools.
I would just make the following observation. When I listened to Professor Kleinfeld and Dean Alexander and the slightly different sort of pictures of legal academia, I think it's important to note a structural issue. The typical professor is maybe 5, 6 or more reporting levels down from whoever it is that has the ultimate formal authority over policy and hiring, whether it's a board of trustees, a governor of a state, you name it. And it only takes one weak link in that chain to make that professor terrified of what happens if they get crosswise with colleagues or students in a way that can be turned into a sort of attack on a protected class or a claimed attack on a protected class. I'm quite confident, knowing the deans on our panel, that they are not the weak link in their institutions. But as I said, it only takes one.
I want to add 2 observations. And Josh, what I'm going to try and do is model this debate thing. This is very, very dangerous to try and do a live experiment here. We're going to have a disagreement. I have 2 observations. One, I'm a social scientist as well as a lawyer, and it is always very dangerous to reason from anecdotes. As generalizable as they may be, because you've taught at so many erudite institutions, it is very easy for me to identify 3 anecdotes to the contrary, right? I can, for example, identify the petition that landed in my inbox with 10,000 signatures on it calling for me to fire or cancel a member of my faculty, Justice Clarence Thomas, immediately after the Dobbs decision came down. And very quickly, we answered, we shall not, right? Because that's not what you do in institutions of higher education. I can point to the fact that when I was at the University of Virginia, my welcome committee, literally 2 days before I arrived for my teaching position, was the Unite the Right rally that turned deadly. And for a year after, Jason Kessler and some of the organizers of those rallies came to use the library at the University of Virginia. And of course, they had the right to use the library at the University of Virginia Law School. In response, we didn't close the library door and tell them that they had to leave. The Jewish Law Students Association, a target of this organization, the Black Law Students Association, a target of Jason Kessler's, and the Lambda LGBTQI+ organization, we held wellness sessions for our students, right? I could go on, there are lots and lots. The ADL came, and our LGBTQ+ students were very concerned. So anecdote after anecdote could be contrary, but this is my point. It's not only dangerous to reason from anecdotes. Anecdotes tell us only part of an evolving story. One of the reasons that it is so important that we have at law schools the clash of ideas that Carl Llewellyn described in the Bramble Bush is so that we could work out these tensions, these contests, these very hard decisions. And what you're describing, I'm certain is true, and I'm certain we would agree was handled poorly on the way to finding the right solution. That's what education is about. So to stop in the middle of the story and say we have this tragedy, a crisis, a parade of horrors, and we must react to the middle of the story, I think forgoes the process of the evolving protection of democracy that Dean Alexander was talking about, the protection and preservation of civil debate and the nurturing of ideas. That's point number one. Point number two is, I see it as a little bit of an irony that your worry is about equity institutions that did not exist historically, when the obvious explanation for why they did not exist is because they were not needed when legal education was exclusively the purview of white propertied males. You didn't need an equity council until women were admitted recently. You didn't need an equity council until African Americans and others were admitted recently, right? So the explanation is so easy that their proliferation seems unremarkable. Now, again, the story is that they're growing. We're trying to figure out how to operate them, what to do with them. And that's the beauty of higher education, right? That's what we exist to do. That's the mission. Again, I refer you to the Bramble Bush. Carl Llewellyn talked about the reason we use the Socratic method in law schools, back to the mission of law schools. The reason we use the case method, the reason we reason from precedent in order to solve problems is because as a society advances and as the problems present themselves, we, again, as a mission of law school, are helping to resolve those and discover how new knowledge and new information and new ideas can help to resolve new problems. So I can think of times when the Constitution was misinterpreted. I don't throw it out because Plessy versus Ferguson was wrongly decided. Neither do I throw out equity and equality and the things that led to the anecdotes that I would agree were mishandled.
as I reflect on your remarks, I'm trying to figure out quite what we are agreeing about and disagreed about. There's no question that some of the forces I described, the aggression, cancellations, the forces of ostracism, are at work. I don't think we disagree about their existence, the existence of those movements. Maybe what we're disagreeing about is the extent to which they're presently dominant. I do think they're presently dominant. I don't deny that in the various kind of assaults on the citadel that are being attempted, some get repelled, right? There are people like you saying, you might have 10,000 signatures, but I'm not going to fire Justice Clarence Thomas. On the other hand, what strikes me about that example is, first, that there were 10,000 students ready to get him fired if they could. 10,000 people, right? That's an example of exactly the sort of aggression that I'm interested in trying to bring to your attention. And also, he is Justice Thomas, right? He's a hard guy to fire. And he wouldn't much care if he were, maybe a little.
Yeah.
But what about...
He wouldn't care.
What about the untenured lecturer? What about the adjunct who gets those 10,000 signatures? There's a lot of people who are in much more vulnerable positions. And they, the anecdote doesn't work out the same way. A lot of the time the dean's behavior isn't the same way, or maybe yours would be. Maybe you would be unchanged no matter who the target of that sort of thing were. But there's a lot of deans who aren't like you then. Really what matters is in terms of creating intimidation, right? When you have a group of people who are ideologically aggressive, who are bent in harm in the way I described, you know, they'll keep shooting. And sometimes they're hit and sometimes they'll miss. But if they're shooting, the culture around you is changing and the law school is changing. So, and what bothers me is that the official ideology, the statements of the law schools, in many cases, the work of the Office of Equity, essentially puts a thumb on the scale of those various ideological conflicts. I do think it's, you know, the sky is dark.
Well, I mean, maybe one difference is the extent to which individuals are getting caught up on this on the way to, you know, as Dean Matthews says, sort of working out these processes. There are a lot of individuals that are, you know, their careers are being ruined, they're being shunned, they're being ostracized, and that is a real cost to figuring out whatever the right answer is, perhaps. There other comments about that? No?
I guess I would just say that I would, excuse me, I'd venture to say that the 200 law school deans in the country, I think if you put two different ones in these chairs, you would not hear different fundamental comments. There's different circumstances. You know, I'm at a Catholic school, Dean Matthew at a private non-religious school, we have a dean from a public school, but to the extent that there are concerns about how leadership is working, the deans of the law schools, I don't think would provide different answers from what Dean Matthew and I are saying. I am the incoming president of the Association of American Law Schools, and this is a message I am happy to take going forward. And I believe one of the reasons why I am in this position is because my peers respect that I take these positions. And so, to the extent that there's a concern for the future and what the skies are like, we got plenty of problems to deal with in this country. I'm not minimizing this as one, but I will tell you that the leadership in the law schools, and this is partly also to your point, Professor, I think Professor Mahoney makes a great point. There are lots of different layers. But I think the deans of the law school are ready for what lies ahead and would say the same things that Dean Matthew and I are saying today.
Can I respond to that? I think some of that is because statements of principle are so flexible and so open-textured and easy to fill in. So sort of everyone can agree in principle, all the deans can agree in principle with sort of like open inquiry and values of good scholarship and scholarly rigor and kindness to one another. But when it actually comes on the ground to dealing with dissenting professors or dissenting students or student aggression, actually they're making very different choices and choices that are consequential for how the law school functions.
Yeah, it kind of goes to maybe the gap between the ideal and the practice. Yeah, I have a question maybe on a slightly different topic that I think was also raised by some of these comments. I mean, to what extent, I'm interested in your thoughts, do you think the mission of a law school is essentially kind of backward looking, thinking about what our law is, what what our history has been, what our foundations have been, and how much of legal education is properly, sort of forward looking into changing the law or, effectuating change? Professor Mahoney, maybe if you want to.
Sure. I think that it is both. I think we can't understand our legal system without understanding, again, basic facts about the society of which it is a part. I think it's also vital to say the challenges that we as individuals and as a society face today are not identical to the challenges that faced people who developed the legal system that we have. And of course, law, again, in my view, is simply a system that supports the society of which it is a part, and then the question becomes, what's the best way for law to do that for the specific society? I guess I would just, observe that a commitment to democracy and political freedom, absolutely essential and central as that is not enough. And the reason I say that is that if you look over the past 25 years, and I'm going to pick 25 years because that turns out to be a period over which we have both measures of political freedom from the nonprofit organization Freedom House and measures of economic freedom from the Heritage Foundation, and so this is not anecdotal. You can see that there have been countries that have suffered substantial declines in political freedom. What all of those countries had in common was that in 1997, when these comprehensive databases start, they ranked quite low on economic freedom. And no country that ranked highly in the Heritage Index of Economic Freedom in 1997 suffered a significant decline in political freedom over the intervening years. And I want that to sink in. So it turns out that economic freedom is a remarkably strong bulwark against the erosion of political freedom. And again, I think that's something that lawyers would probably be well advised to keep in mind.
Thoughts?
Well, I'll share one thought. I mean, it's a little old-fashioned. I think of myself as, in my teaching, not in my scholarship, but in my teaching, as trying to transmit and preserve a craft of good lawyering. And it is primarily not a project in trying to bring about a more just society or trying to reform society in some respect. There's a kind of a precious inheritance, and I'm in the privileged position of trying to impart that inheritance, simple things, how to analyze a case, how to think about a holding, how to think about the ways in which the various departments of law cohere with one another. None of it is obvious or intuitive. All of it needs to be preserved and handed down, and it's simply a process of preserving a great tradition for the next generation. So it's rather backwards looking. I guess there's another factor, if I'm being candid. I think projects in justice reform, projects in accomplishing, sweeping social change, release a spirit of self-righteousness that is part of a psychological process that paves the way for cruelty and aggression. And so I don't think self-righteousness and projects in justice reform, high-minded as they might appear to be, are actually innocent. I think they're often very sinister because of the ways in which they sort of prepare normal people for the kinds of aggression I worry about.
I'm so sorry.
We're going to turn to audience questions.
I'm so sorry.
No, you should go ahead. I was just going to say if people want to come to the microphones. Well,
there's no data to support that connection whatsoever. There is data, however, that shows that dehumanization releases cruelty and aggression. There's data about that, but
I disagree with that.
Okay.
Respectfully, there is data showing that when people believe that they are armed with the right and their opponents are therefore enemies, they are prepared for aggression.
There is data for that, but there is no data, I would submit, that says that if you pursue justice, you release cruelty, and that I thought was your statement. So let me just make the observation that I do agree that law is both backwards and forwards looking. Mm-hmm. There is absolutely no question that that's right. I also agree, Josh, that there is an essential mission of teaching the craft of lawyering, how to research, how to write, how to reason. The skill of reasoning is essential to the legal education. But one of the things that we haven't talked about that I think law schools ought to do better than we're doing right now is unifying the values that students come in with. We get these glorious essays about how people want to save the planet, save the whales. And what they leave without, I think, produces, again, this dispiriting dissonance between their personal values and who they are when they begin this, what I consider a very noble profession. And so one of the things I'm excited about doing as a dean of a law school is helping form professional identity, including in our legal canon, the skill set of how to craft, but also how to integrate your ethical values and that lofty indeed goal of solving the tensions between equality and liberty, justice and fairness, and keeping that central to the practice of law and the use of a law degree. So professional identity formation, the competencies of what it means to not just be a good lawyer, but an excellent counselor. I think and say often to my students that you will be the best equipped reasoner in the room after your legal education, whether you ever practice law or not. If you go to the PTA meeting and there's chaos, you will be able to bring order to that chaos. If you go to the HOA Association, if you go to a corporate board meeting, if you go to the United Nations, a legal career helps you reason through chaos, bring order, to connect dots, if you will.
And I just quickly tag on to that. The backwards and forwards, we are a profession where we build on precedent, for example. We look to see what was decided before to see what is the right answer. This is what the judge does every day. But then we look forward and we ask, how can we participate in this noble experiment to form a more perfect union? How do we make sure that we are not just okay, but that we are better as a society every day? And we train our students not just to be the technicians, to be Bartleby the scrivener, but we train them to be part of society in any kind of context, to make a difference. Because we are privileged to be lawyers, to be part of this noble profession. So we just want to make sure our students understand their opportunity, their obligation to make a real contribution.
Okay, I'm just going to alternate between the microphones. We'll start with the front here.
Yes, thank you. My name is...
It's a very important question.
Francis Menton, Manhattan Contrarian. I guess my question is mainly for the two law deans, maybe in a few parts. First of all, do you require a diversity statement from applicants who come in? And second of all, is that diversity statement then used as a form of loyalty oath or conforming oath to exclude people? So that if somebody, for example, said what Gail Harriet, who's speaking here later today, said in her book, A Dubious Expediency, and I think she also said in her amicus brief in the Harvard case, I'll try to summarize. I hope I don't mischaracterize her too badly, but something like the affirmative action is harming the intended beneficiaries, creating a class of people who are obviously unqualified to come in, who end up at the bottom of the class. It humiliates them. It leads them to have worse careers than they otherwise would have had. Suppose somebody says that in their diversity statement. Are they hireable at your school? Or is that just, that proves they're a nonconformist and we got to exclude them? How does that work at your school?
I'll be clear, there's no loyalty oath of any sort that is required.
Do you have a diversity statement?
And we ask students, we ask we ask for folks to tell us their contribution to our mission as a Catholic Augustinian institution. But what's I think extraordinarily important is that I ask people, when I interview somebody, how will you contribute to our bigger mission? And I ask that because I want people to know from the start that we are doing something that I believe is very important. As I was saying before, it's not just to become a technician, but it's how can you somehow live out the values that we as a Catholic Augustinian institution have when we talk about truth, unity, and love. How can you contribute somehow? It could be anything that you want, but the important thing is, yeah, these feedbacks are quite something. The key is that it is not there is no loyalty oath. I think it is a great misconception that there are loyalty oaths out there at schools. You know, what we do, if we do our jobs right, we're asking people to be loyal to the pursuit of dialogue, to the pursuit of discussion, to the free and open exchange of ideas. That's what we do. Loyalty is to the process of great education. Loyalty is to, you know, for our lawyers to defend this system. Ultimately, we all take our oath as lawyers. That's a loyalty to our system. That's what matters in what we do.
We'll go to that.
And I'll say no and no. I think we've just added a statement because so many people were using our impact statement to show their diversity. We've added a statement that's more like what Dean Alexander said. Just tell us what you bring to the class. And to get to the fine point of your question, if someone said that I bring a view that people are being admitted that shouldn't be admitted and they end up at the bottom of the class, that would not disqualify them from admission to our law school.
Thank you.
Question in the back microphone.
Yeah, thank you. Coach Winehouse, please accept for the purposes of this question that Professor Kleinfeld's paradigm 2 is a reality and not a good one. Assuming you weren't responsible for the preservation of the institution, what steps, if any, would you advise to encourage the expansion of law reader programs? That is, bypassing law school altogether for the practice of law.
So let me make a broader point in response to that question. I suspect that the next, say, decade will be a time of substantial innovation in the delivery of education at all levels. And I think that those innovations will put pressure on any institutions who are in the paradigm 2 that Professor Kleinfeld has noted. It is obviously a lot easier to reach people today through technology. I think there is a growing view among a lot of people who would otherwise want to go to traditional four-year colleges that the value proposition is not always there. And I think you are likely to see a diversity in styles of gaining both intellectual and professional training.
I want to agree with Professor Mahoney, but I just add something. I think brands are very powerful and very hard to recreate. I was recently talking to a family, immigrant family whose kids had done very, very well in high school and had the prospect of going to top-notch universities, but this family was also quite worried about indoctrination into values that they themselves thought were completely alien to them and false. And I said, well, you could consider, instead of sending your kid to, a Yale or a Princeton or a Harvard or something like that, you could consider one of these liberal arts schools, these lesser known schools that would maybe have an education that's more in keeping with your values. And they said, but we love our children. How can we put them in a school? How can we deliberately give them less of the brand that would certify them as a member of the American elite than we otherwise could? They felt stuck. And I think that's a powerful reality. I don't think the solution to paradigm 2, if it is indeed emerging or has emerged, is to try to bypass these extremely powerful institutions and brands. It's to be prepared for fairly radical reform of those institutions.
Can I just very quickly respond that brands are powerful until they aren't? FTX was a very powerful brand a week ago. It's not a powerful brand today. And it is in the nature of these things that things look very stable, very powerful, until someone figures out how to compete with them, and then they're not.
Go to a question here in the front.
Professor Mahoney, a question for you. So UVA Law School is somewhat unique among top law schools in that it has a critical mass of conservative law professors, especially in the public law fields. Prakash, Harrison, NLC, you can keep going on. And you've served as dean for a number of years. What is UVA doing differently than other law schools? And what could other law school administrations learn from what UVA is doing when it comes to recruiting and sort of maintaining sort of a robust, intellectually diverse faculty? Thanks.
So it's a great question, and I think part of the answer has to do with the fact that the faculty in our law school historically, and I think to this day, were very willing to put in work at the time of hiring faculty. They cared about whether someone's scholarship was genuinely rigorous, and that was more important than the particular conclusions that the person reached. And that's hard, I think, to sustain in a modern academic institution. All of the incentives are for professors to spend every moment that they can possibly spend on their research, which is the only thing that's visible to anyone outside their institution, and minimize the amount of time they spend on any kind of administrative duties. That, by the way, is related to an issue that we've touched on a little bit, which is the extraordinary growth of the administrative arms of universities. The people who went to law school in my era, the faculty made admissions decisions. They provided academic counseling. They ran the disciplinary system for students. Those things are really hard to do well, and they take a lot of time. And eventually, faculty at universities generally decided, we don't want to do this. and they turned those things over to administrators. There is a little bit of a movement that I see certainly in universities generally, less so far in law schools, to have the administrative end more and more involved in the faculty hiring process. I think that's very corrosive, and I think any law school that wants to remain a place of pluralistic values really needs to encourage faculty to be fully and sincerely involved in faculty hiring.
I want to grow up to be like that. It is one of the things that really did attract me to GW, that we also have a critical mass of scholars who would be, I think, self-identified. And I've got one of my colleagues here who I won't call out, but I just want you to note that the limit of service-oriented work is one of the reasons that UVA has been successful in that. So Brad Clark and I'm sorry, I have to call your name, Scott Keefe and Renee Lerner and Bob Cottrell. I'm trying to do exactly as I learned at UVA, to focus so exclusively, if not primarily, if not exclusively, on scholarship and the ideas that are generated by our faculty that they have time to develop. And that's what I think will attract a variety of viewpoints successfully.
All right, Charles Miller from Ohio, and I guess my question is a follow on that, which is to the next level, should legal academia and law schools be actively recruiting and seeking to expand conservative and libertarian viewpoints on their faculty?
Yes. So I have an anecdote. The first fully endowed chair that we were able to attract to GW Law School is for a professorship in free speech and First Amendment expression. I'm searching for that person now. Perhaps that person is in the room. But we are actively looking for someone. See you right outside after. But yes.
I think so too. I agree with that. I'm glad to find that we agree about some stuff.
There you go.
I don't think we disagree quite as much as it appears, but there's a body of research about what happens in ideologically unified environments, and summarizing a lot of nuance. The basic finding is that people develop extreme views and often distorted views of both fact and value when they're in ideologically unified environments. It's actually fascinating to read these studies. They'll take a group of people who are mildly skeptical of climate change. Maybe they think it's happening, but it's not a dire problem, or it's happening, but it's not human caused. Put them in a room and have them discuss it for 3 hours with no dissenters. And they will very likely come out of that room fully engaged in climate change denial. They'll say it's not happening, it's a myth, it's a hoax. Do the same with the other side. Get a group of people who are concerned about climate change. It's one among other problems, but they're concerned. Put them in a room talking about it for 3 hours in an ideologically unified environment, an echo chamber. And they'll come out of it convinced that the world will end in 50 years if we don't change everything now. It seems like, in fact, people have even been convinced of such things as like looking at two lines that are the same length in an environment that is, if they're surrounded by actors who affirm that one of those lines is longer than the others, they are perfectly capable of coming to see one of the lines as longer despite what their own eyes are telling them, coming to see a color as red when they can see that it's purple. Also, all sorts of incredible distortions in basic perception, let alone the complex judgments scholars need to engage in. And what that research suggests is that if law schools are a highly ideologically unified environment, we can expect them to act as an amplifier for whatever the existing ideological orientation therein is. And I think that's part of what we are in fact seeing, and then it's a strong case for ideological diversity.
I would just add to continue that. You know, our faculty, I believe, we have really an exemplary range of views, points of view, ideology, however you might put it. And it's important because, to build on the previous points, then the students are in an environment where they are seeing different perspectives, learning from different perspectives, and therefore able to determine their own ideas by not seeing that there's an orthodoxy, but to see that we are nurturing open and honest debate at all times and all levels. And that ultimately, I think, makes our students strongest.
All right, thank you.
Ilya Shapiro from the Manhattan Institute and Professor Emeritus from Georgetown Law. I have a question primarily for the deans, building on Professor Kleinfeld's opening remarks. And I want to drill down past the website platitudes and banalities about nurturing justice and things like this, and actually look at the crisis in legal academia from the two perspectives of official policy or non-enforcement of policy and social pressures and culture. So whether you look at anecdotes or whether you look at the data from organizations like the Foundation for Individual Rights and Education that talks about the increasing cancellation and job threats to professors, the student survey that overwhelmingly self-censor, 3/5 say it's okay to disrupt events, 1/5 say it's okay to use violence to shut down speakers. The subversion of the goal of truth-seeking and civil discourse, in part by the explosion of bureaucracies such as DEI that subvert intellectual diversity, oppose equal opportunity, and exclude those who deviate from progressive orthodoxy. What are you seeing from the inside, and what are you prepared to do as leaders to instill these values directly of speech and civil discourse, as well as law schools have been good at instilling values of social justice, public service, diversity, and things like that? Because whether you care to say so explicitly to this group or not, there is a real crisis in law schools, and that's both through official action, inaction, and culturally speaking. Thank you.
So my answer is going to be short so that I let you do the whole, the long thing. My bona fides are pretty strong on this at this point. And I'll only say two things in terms of the crisis. The crisis doesn't originate nor exclusively reside with law schools. Civil debate, cancel culture is a crisis societally. My office sits on the corner of 20th Street and G Street. And I had to shelter in place when people walked past my window with AK-15s in order to cancel an election. And so it is not only a challenge and a crisis inside the academy, it's one for which I would suggest we all hold a card we need to play in civility. I don't think those ideals are just lofty. So what I'm prepared to do, I've done, and will continue to do. But remember, canceling has only recently turned towards the viewpoint that you prefer at this point. It was historically my viewpoint that was canceled. I couldn't go to law school, couldn't go to college. Canceling is endemic on both sides of the viewpoint. People are passing laws to say that we can't teach critical race theory. Right? So I think we can together agree that the crisis requires all of our attention without pointing fingers at one side or the other.
And I would add to that, first, to reject your label of website platitudes. This is my lived commitment. It's my friend Dana's lived commitment as dean. I go to when we have speakers who are controversial in any way, I use my dean's prerogative to introduce the speaker and to set the conditions for the debate. And I say, everybody here is welcome to speak with respect, with intelligence, with passion for your position. But we're not here to silence anybody. If you are here to have an honest, open debate, you are welcome, whether you are the speaker or the audience. So, throughout my career, and certainly as dean, I have said we must set the conditions by which we engage in conversation. And that has made people happy and some people unhappy across the political spectrum, which maybe sometimes makes me feel like I'm doing my job right, because sometimes folks say, you must do it this way, and I say no, but then somebody who they don't agree with says, you must do it that way, and I say no. This is the way we do it. We engage with respect. We engage as a community. We engage with intelligence, with passion for what we know to be our beliefs. But at the end, it's all about respect, and I will say it again, with love for each other as brothers and sisters. I reject, again, your characterization to make the point, not to say I'm rejecting what you're saying, but the website platitude, no, it's my lived experience. And I challenge all of us to greet those people who we think of as disagreeing with us with actual love and respect as brothers and sisters. And to say that to people, and to say we may disagree, but we're still going to treat each other a certain way that we expect to be treated.
Thank you.
Yeah,
Throw in one thought on this. I think, where is it, Ilya? I think the problems you're pointing to did in fact originate in the university and have spread to the wider society, and they're older than we might think. While you were speaking, I picked up my phone. I hope it wasn't rude, but I wanted to look up when Closing of the American Mind by Alan Bloom was written. It was written in 1987. You know, before we called it canceling, the first wave of culture wars were in the 80s and 90s. And they were about all the current stuff. They were about identity. Back then it was called identity politics and political correctness as opposed to wokeism. But that's just a change in label, right? And the same sorts of tactics of trying to get people fired or excluded or ostracized or shut down were all present. That's what Alan Bloom was writing about in 1987. Now, they were much less common. But I think what's essentially happened historically is that something got started, and I don't know exactly when, 70s, 80s? Something got started in American universities. Respectfully, Dean Matthew, it might have been in American law schools. I don't actually know, but it got started in American universities. And what we've really seen is its corrosive effect spread outside of, it used to be that, a lot of people sort of shrugged and said, well, universities are crazy, but eventually people graduate and go into the real world. That was naive. That was the belief that ideas didn't truly matter. Because what actually happened is this quote-unquote real world was remade in the image of the universities. People graduate. They're grown-ups when they graduate, and they go out there and they remake institutions. And what we're experiencing now is in the sort of cancer culture in society more broadly is the spread of something that started in universities to the rest of society.
Thanks. Question in the back?
Yeah, Ben Flowers, the state of Ohio. In talking about the mission of a law school, I think most or all of you began with the lofty ideals and only later came around to the trade of lawyering. I don't think anybody mentioned teaching doctrine. And this despite the fact that 99.9% of your students will be effectively tradespeople, much like a carpenter or a plumber. They will use their skills to help to fill the noble role of helping clients solve problems or achieve goals. Given that focus and given the fact that legal academic scholarship is largely irrelevant to the practice of law, should we be concerned that you're creating students who are not only ill-prepared for, but disillusioned with the career they're entering?
I missed the very end, but I think that we are training our students, and listening to what Josh was saying, there's a core of what we do to train them to think, to read, to write in a way that will make them good practitioners. And I am keenly aware that that's what my students will end up doing, is practicing law in some fashion. And so to me, that's always going to be essential. I also do it knowing that they will be called on to do more in society than most. We lawyers are called to do more in our society. We are disproportionately influential. We're disproportionately involved in government. We have, there's so many ways in which there is more to what we do. And I think that what I want to make sure my students know is that they must be good practitioners, and they exist within a system of laws in our country. And we have, I think, a sacred obligation to preserve and protect that. And so, first they've got to be lawyers, but they have to do it within understanding the context of the system of laws.
So I'd like to just respond to that quickly as well. I mean, I said in my opening remarks, I think the pendulum's probably swung a little bit too far in terms of law professors not having enough connection to legal practice. But having said that, one of the things I constantly tell my students is, look, if the answer's clear, you're not going to make money off of knowing what the answer is. So what you need to be able to do is identify places where the answer is not clear and have a toolkit that enables you to make a persuasive argument that the answer that would serve your client's interests is an attractive answer to that particular problem.
I just want to say, yes, I should be concerned about that. We all should be concerned about the problem that you raise. But I am going to tell a story about a colleague that you will recognize. When I was first in the Legal Academy, one of my colleagues read a draft of what I had written and invited me to go out to lunch. And the lunch spot is no longer in Charlottesville anymore, but he took me to a corner in the booth in the back in the dark to sit down and have a conversation. He said, this is a good article, but let me just explain to you, you're not going to get tenure talking about policy. You're not going to get tenure talking about concrete. Your ideas have to be big. They have to be innovative. So this section of the paper, which was most of the paper, you need to move that to the side. That is no longer true anywhere. And I think it is important to recognize, well, our faculty just passed a strategic plan, and we called our brand of education a DC-infused education. That is to say that moving in and out of the private sector, the public sector, and the classroom, you could testify in front of Congress at 9 in the morning and teach torts at 10 in the afternoon. That's our brand. That's who we are. It's now valued that students will do field placements, an internship at the DOJ, at the FTC, at the SEC, as well as course credit. Experiential education is becoming more of an important component of the legal education curriculum. So I do think we are expanding, and we're doing it in part because the value proposition has changed. The business case for a lawyer who can only think like a lawyer but can't do anything else is too expensive for clients to pay for and therefore for employers to hire. So yes, I do think we have to be concerned, and I see a response in the academy.
Okay, I'm actually afraid that we are now out of time. I just want to remind you all that Senator Lee will be speaking here at 11:15, and if you could all join me in thanking our wonderful panel.